Good morning, everybody. Hello. Giving me just a minute here. We've got a hearing going on in Georgia. They've started to record it, but I will be a little bit behind the hearing, but I thought we could hang out and talk about the hearing as it goes forward. Good morning, Suze. Hello. Let me just double check here. Oh, you're a juror. Really? Hopefully not on this case. If so, you should be skedaddling. Oh my goodness. Oh, you're a juror, maybe in our regular fun jury kind of way. Yes, good morning, everybody. Good morning from Michigan. Hello, everybody. Welcome, good afternoon. Hi there. Hello. So I yes, that's you. Okay, you're on the you're on our fake jury. Oh my goodness. Hello. Oh, thank you so much. Well, welcome everybody. Yes. So today they are having a hearing right now on the juror questionnaires. So they're really going through the pros and cons of the different kinds of questions that both sides are wanting to ask. They gave a list to the Judge McAfee, and so he's kind of going through the questions one question at a time to get agreements from the government as well as from defense. So I thought we could go through this. We're a little bit behind the actual hearing itself, but I thought it'd still be worth it to go through. So hopefully this will be interesting and helpful for people. I'm trying to see if I can get everything in view, though. Good morning. We will see here. I keep trying, but I'm not sure. Hold on. I'm still working on it. This is the Georgia case. This is the RICO case. We're set to go to trial then on Monday, but we will have jury questionnaires starting on Friday with the first panel of 450 from the Venere. Yes, oh, absolutely. Okay, is it okay, Suze? Thank you very much. So fabulous. We'll go ahead and get started then, everybody, if you've got questions. Yeah, the courtroom is pretty empty. Again, this is just a procedural hearing where they're going to go through the jury questions, but I think it's actually very interesting. That's why I thought, I'd go ahead and go on and just kind of go through what the questions are. So good morning, Jay. Hello, good to see you. All right, everybody, I'll go ahead and hit play. So let me know if it needs to be better in frame or if it's not loud enough.
Our reason for gathering today on the questionnaire, and in no particular order, I just made a list and then I can run it by the parties as well. We have heard back after following up on the motion to interview the grand jurors.
Thank you, Suze.
We have two individuals who expressed interest. And so the plan would be, and they've said their availability would be for Friday afternoon.
Good morning.
So the idea right now would be after the questionnaire is completed, that we would arrange a specific time for everyone to be able to hear from those individuals to put forth the approved questions to them. I had told them tentatively 2 o'clock. We'll see how long it takes to complete the questionnaire. I would think we'd be done by then. And that'll either be...
Right now they are talking about the questionnaire that they are going to be giving to the potential jurors. So it's too soon to pick jurors, but right now they're trying to figure out which questions are okay and which ones are not, because from the very first moment that you speak with someone who could be a potential juror, there is this potential to taint the jury pool, so they have to be pretty careful.
In chambers, depending on how many people need to be present for that, or we'll find another space that'll be on the record, but
sticky note,
that
sure.
would not be a public proceeding. So I would just say right now to also reserve your Friday afternoon for those two interviews. Mr. Roy.
Is it all right if I just talk?
That's fine. You just make sure you're loud enough.
So on Friday, are we just introducing ourselves and you're passing out the questionnaires and we leave, or do you want us to stay while they're filling it out?
So that goes right into the next thing I had here, which is what we anticipate Friday looking like. I would say the plan right now is that the parties and the attorneys, we can stage in this courtroom at about 9 a.m. And then there wouldn't be really anything on the record unless there's something we need to address before we get started. But we would wait here until we hear from our
Good
jury clerk.
morning. Good morning.
Because while we're here,
Let's see if I
the
can
other 450
put
individuals
this
will be
down.
checking in 7A, getting seated, doing a roll call and that sort of thing. And then once we get a thumbs up from the jury clerk, we would make our way upstairs and be seated. We'll have a kind of an impromptu area set up in the center of the room, and I would start off with just the usual introduction, the script that we do for every trial. I'm putting that together. I'll send out a copy to you all at some point this week, probably Tuesday or Wednesday, to see if you have any concerns with it. And as we had talked about before, the idea is not that we're reading the indictment at that point. We would reference the parties, and if we want, we could do an introduction at that point. We could also do it before each panel.
We are a little bit behind. This is a recording, but this hearing has been and continues to go on this morning. We are just a little bit behind, but we're close. Can everybody see this okay? I'm trying to make sure we've got... Not going to get any work done. Well, get your work. Do your work. So hopefully this is okay for everybody. Okay, thank you. Thank you very much.
Maybe it's cleaner just to do it right then in front of everybody. In terms of, again, whether your clients want to be there, for this point, if this is the idea that day is just to be passing out the questionnaires, I'll leave it up to you. Since I still think that's something that they could waive if they wanted to. And yes, the idea would be after introducing ourselves and going over the parameters, that then the questionnaires are right under their seats, and then they proceed to fill them out. If you want to wait and make sure that they're doing that, feel free. If you want to get up and wander around and make sure they're not talking amongst themselves to share answers and that sort of thing, feel free. Or just bring a book, because we'll be there for an hour or two watching them fill out the questionnaires. We collect them.
Bring a book.
And then we're done for the day for that portion. Obviously, now we've mentioned that we'll have something in the afternoon, but that's all we'd be doing Friday. And then those are going to start be getting uploaded to the shared drive that we'll have in place. Again, I want to remind defense counsel I still need the emails of who wants access to that. I've got those from the state.
Give those after hearing this morning to us.
All right. So let's see what else I have on here. I need to ask how many people would be attending the questionnaire session on Friday, so we know how much seating we need.
Yeah, Ms. Powell, it will be myself, Ms. Fry, and very likely my client.
All right, so
Hello,
3
Bob the
plus...
4 for us, Your Honor.
Okay, and from the state?
Because we have 5.
5. This is the initial
right.
set of questions for the initial questionnaires.
I'm sorry, it's 5. I forgot about Mr. Government's associate. 5 people, Your Honor. 5 from Mr. Chesler.
Right, okay. So a total of 13 chairs we'll have up there. I don't know how many tables that'll take. We may just have to be in one long one. We'll see.
Sure, can I explain who's in court? Sure. We've got Cheese Bros counsel here. We have Mr. Lemonade, Mr. Not Lemonade, and his assistant. Here's Cheese Bro, here is Powell's attorney, and I think his assistant. And then over here we have all of the state prosecutors. So we've just got Cheese and Crackers. Yes, Cheese and Crackers attorneys, and they're talking about this initial set of questions. They will give a sheet out to the jurors that come in on Friday. There's 450 of them. The jurors have to come to the courthouse. They have to fill out the questionnaire and then turn the questionnaire in. So what they're doing right now is they're discussing both sides and the judge what the appropriate questions are for the questionnaire, because you have to be very careful with your jurors. You don't want to taint them at any time, even if they're not even chosen. So we're just being very careful on making sure there's plenty of room there, on making sure that the questions are appropriate. So if you ask a bad question during a jury questionnaire, you could have an appealable issue. So they're trying to be super careful. Good morning. Yes, 450 this week, Suze. And then if they can't find enough, then they'll have another 450 next week. So it's a lot. Absolutely, it's a lot.
And all right, so that should take care of that. Also wanted to note, since we're getting in, although we're not reading the indictment to him, we are getting into a place where y'all might be talking about redactions and that sort of thing. And I wanted to note, I've been informed by the Superior Court clerk that when the original indictment was uploaded to Odyssey, it gets scanned as a PDF, and I don't know the exact legal terminology, but then converted into a digital copy. Long story short, the numbering in the indictment was not scanned correctly. So some of the overt acts, the numbers aren't in a sequential sequence as they were actually in the original document. So my plan there was, if y'all can either, since you're working on a redacted copy, I presume, correct it in the redacted copy, or I'll probably be putting out an order noting that the actual, basically rescanning it and saying that the true indictment is the attached, and maybe even striking the original indictment that was on the docket since it was just scanned incorrectly. So I just want to note that for y'all so you don't get surprised when maybe the indictment is corrected. Anything on that? Any preferences? Okay. I'm not seeing any from either side.
Can we have a deadline on when we can get the redacted indictment, just in case there's any issues before Friday? If you're gonna.
Well, I mean, at this point, I don't think, since we're not planning to read it to him or give it to him, I don't think we need to have that deadline Friday.
We won't be doing the summary Friday.
Okay, so I'm pausing for a moment. So Mr. Not Lemonade, as you all know now, is really becoming to me just like an itch that cannot be scratched. He's quite annoying, and I say that with the utmost understanding of his very prestigious background in legal work. He drives me bonkers, and he continues to ask for every single tiny thing in the entire possible world. Right now, he's asking the judge to set a deadline on when they can get a redacted copy of the trial information or the indictment. And they should already have this. This should already be there. So the judge is saying, no, I'm not going to put a deadline in. What are you talking about? Yes, so this attorney here for Cheesebro is Mr. Lemonade, and then this is Mr. Not Lemonade. He's got two attorneys. This one's kind of whatever. But this one, no, I don't know. That one's just gets me the wrong way. Oh, my goodness. Form of dragging one's feet in the legal sense. Yes, it is. I'm not really sure what his deal is. Like, I get it. You need to follow and do the best that you can. But I don't know. For some reason, he just rubs me the wrong way. So here we go. He's asking again for this time limit to be set. And the judge is like, that's ridiculous.
Well, there's a summary that appears in the questionnaire, and we'll talk about it. But I think that could be sufficient for us. It's going to alert everyone to generally the nature of the case and what it's about. And I think that could do it for us. So in terms of anything more than that, we'll get to it. I still need a defense witness list to add into the questionnaire. Has that been submitted?
We sent that this morning.
Perfect.
It's for Ms. Powell. I don't believe.
I think we may have sent it as a PDF. We'll send it as a Word document. That's what you want.
That would be ideal. Yeah, okay.
Try to do that while we're here now. If the internet's working.
All right, and then the last thing I had was just kind of a summary on the pending motions we have. I'd seen on the docket the state filing a motion for a protective order, and then some things from Defendant Schaefer about conferring with the state. Is that something we need to have in place by Friday, or is that something y'all are still working on? I hadn't really heard much about what's going on with that one. I hadn't planned to enter an order until I got some direction from the parties.
Wait,
Okay. All right. Well, I will await further direction from the state or from Defendant Schaefer, since I think he was the only one that voiced any concern or interest in it.
Just to be clear, I think he was speaking on behalf of all defendants. We all kind of joined, agreed that Defendant Schaefer's attorney would lead those discussions. So we do also have concerns about the state's proposed protective order, but we agreed to work through Defendant Schaefer's counsel with the state to address those before we bring it to you.
Okay, understood. Thank you for that clarification. And then I think I should have responded. Was it Friday, Mr. Grubman? We got a witness petition from your team, and I just wanted to add that we would want a proposed order to go along with that.
We did send that on this weekend, I think.
Okay. All right. Well, then it's probably making its way to us. We usually have to kind of dig through some emails on Monday morning. And then again, this may have been something we've already clarified, but on the attorney-client privilege issue, where both sides submitted some materials, I think on Friday, again, in the interest of completing the record, was the intention that those, I know obviously we've got some that are in camera, but with the state submission, was that also supposed to be in camera, sealed, part of the docket? Any thoughts or preferences there from either side?
Because our thinking was it would all be in camera.
Okay, understood. All right, anything to add from the defense on that?
I don't feel extremely strongly about this, but the reason ours is in camera is because it's potentially privileged. They have a burden of showing prima facie case of crime fraud, so I don't know what the basis would be for them to submit their submission in camera, because they're arguing it's not privileged. So I would say if they don't want the media to see it, that's between them and the media. But I would say we need to be able to.
I don't have a specific link here. You can go onto YouTube and put in Scott McAfee's Zoom and the Cheesebro Powell questionnaire, and it should pull up. There are actually a couple of different places. This is a recording. The hearing is going on. We're about an hour behind here, which is fine, but this is a recording of that. But the live version and also another recorded version you can find on YouTube. Hello, Steffi. Hello, everybody. Right, so this is Mr. Lemonade, and he is, just in case anyone's wondering, he is Mr. Cheesebro's attorney, one of two. All right, so here's Mr. Cheesebro, and then we have Ms. Powell, whose attorney is not speaking at the moment. So there you go.
Oh, well, I think haven't they already provided it to you? Or was it just sent to us?
You did not receive it.
Oh, well, that's certainly something you would see. I think it really was just the question of whether it's going on the docket or not.
We can keep it under seal, but we'll forward the email to them of the
right
documents that we submitted.
Okay, so we'll include that with the sealed information provided by both sides.
Thank you,
obviously,
Willa.
I think writing an order, I'm going to be referring to portions of it and that sort of thing. Okay. And then in terms of the rest of the remaining orders, the plan right now is not to have any other. I think I've got everything I need, and I've been working through all the cases cited and all the responses, replies, and replies. And right now the plan is, unless there's some kind of new emergency motion that comes up, that we wouldn't have any hearings between here and Friday, just an FYI. Okay.
Hello, Greg.
I imagine you won't be too heartbroken about that. So let's dig into the questionnaires now. I'm tendering for the back and forth, deletions, edits, proposals, and that sort of thing. And when we're done with this process and we come up with a final questionnaire, I'll tender that as Courts Exhibit 3, again for the record. So digging into it, again going off, we'll just take it section by section. I'll just go off the latest line edits provided by the defense. I didn't see any concerns with the introduction or the background, but we can just go ahead and start there since we already mentioned it. So the background would, again, the intention would be that could serve as the introduction to the indictment, sufficient to kick off the voir dire process. Is that everyone's understanding, or any other thoughts on the background section? It's very brief. We've got, essentially 4 sentences there.
Oh, you're welcome. I'm glad we caught it. We're a little bit behind the actual hearing, but
I just know that
okay.
in some cases, after introducing the state, there'll be a request to say, read the indictment. And this would serve as the substitute for that. That's the idea.
Actually, we would actually request that you actually do charge the substantive acts that are alleged, such as filing false documents and the like.
When you say charge, what do you mean?
Not charge, but like listed, including the Georgia RICO Act, didn't go on filing false documents, etc.
And when you say listed, do you mean in the questionnaire or actually verbal?
In the background section.
Okay, so if that's the case, then I'm going to, let's see your proposal in writing, what you're saying needs to be added. And when you say list, are you saying actually read each count?
Not read each count, but just read the charge itself, like the.
So essentially saying that Mr. Chesbro has been charged with RICO, false statements, this, that, and hard stop.
Yes.
Not really going into the substance of it, just the title of each charge. Okay. All right. Anything else?
That's it.
Okay. Mr. Rafferty.
We would ask that you read it as is, Your Honor.
As is. Okay. And so not to read the substantive counts?
Correct. Yeah, that's right.
All right.
I'm looking through the counts right now. So.
Okay, then back to the state. Any particular case law or reason why you think we would need? The defense is saying they don't mind it. Any particular reason why you feel?
So the judge is saying he has written out this brief introductory, right? Because the indictment is so huge that it would take forever to read the whole indictment, right? So we also have a total of 41 counts charged here, but not all of them apply to these two defendants. So what the state is saying is that we'd like you to read the actual name of each count. So let me give you an example here. Not necessarily every count, but so right here, solicitation, violation of oath by public officer. So they want the judge to read the name of the count. So not necessarily go through all the counts, but what the actual charge is. That's what the state's asking. The defense is saying, we're fine with that introduction that you've already written out. And so the judge is saying, well, what's your problem, state? Why do we need to have that? Why is that necessary? And if that's really something you want, you're going to need to put together a written request for it.
Feel we need to have each count outlined?
Just the counts charged, I think that gives a
Right.
better overview of the background and what they'll be considering and being able to file their questionnaire.
All right. I will, if you want to submit, well, actually, I guess you don't need to submit it over if it's just going to be listing the charges. I'll take that under advisement.
We only ask the ones charged for Cheeseboro.
No, I understand. Okay, then we've got kind of outlining the jury service section, saying, giving everyone an expectation of when we'd be off and when we'd be on. And then I tightened it instead of...
I think he will be very interesting to watch, Stuffy. He is just, all business. So I think he's going to be very, very interesting.
A range just to say 5 months. Maybe we'll do better. But that's where I landed. Any thoughts, final thoughts about 5 months from the state?
He's predicting 5 months for the trial.
Mr. Rafferty? Okay, Mr. Voir.
The December 18th through 29th, are we coming back on the 30th and 31st, or should we just make it through January 1st?
Well, I think those are a weekend, right? Yeah. So I said all weekends are off, and then I'm just listing the weekdays that are also off for holidays.
The judge is like, read the document, Dingle.
It might make sense to include that because there could be jurors that think that.
Sure.
Have you seen the judge get really irritated? Well, he's holding it in pretty good, even now, the way that he's looking at Not Lemonade. Because Not Lemonade, if you remember, well, you probably don't, but back in the Zoom hearing was like, I've got another trial that might be going, which is probably bologna sandwiches. He probably just wants a longer Christmas break because he's got travel plans. But the judge was like, well, we'll see. And so now he's saying, well, what about these dates in December? And the judge is like, look, I just said we have weekends off. What's the matter with you? Can the judge fire a lawyer? No, unfortunately. Our courtroom's typically this size. This one's pretty small. This is a very small courtroom in general. And I'm saying that coming from a small jurisdiction. It is small. Yeah.
Are going to work because they're not going to realize that that's a weekend or something.
All right, I'll do that.
Well, there's a lot of people there.
Sure. Okay, and then getting into the more substantive questions. The first.
It's a great question.
Start off with-
That's a great question. And that, how do they afford 5 months off? It's atrocious. It's atrocious. There are laws passing. You can't lose your job. But as far as financial compensation goes, it's terrible.
The statutory questions, which it looks like someone from the defense side was kind of tweaking some of the language and deleted the third. Any thoughts there about why?
Steffi, no.
Or number 2. A, B, and C.
You don't have a C on those.
Well, that's right, it got deleted at the defense request, and so I'm wondering why.
Well, I think the question, number C, the one I think you're referring to, I'm not really
Powell's
sure what it
attorney?
means to say whose minds are not perfectly impartial between the state and the accused. I think the original 2 questions was just...
Hold on. How much prep does a judge have to do for a specific trial? Typically, judges, they all have their own unique style and how they deal with it, and especially with once you get 10, 15 years under your belt. But with this particular judge, he's got so many different jury trials going on. I don't know when he has the time to sleep. And I think what he does is, as he goes along, a lot of people, will take notes and figure things out and then put it to the side and be like, I'll come back to it. This judge is in the moment all the time. So every question, every answer, all of those things, he's doing it in the moment and just making a record of it, as opposed to repeatedly saying, well, okay, later. He does do that a little bit, but not very much. I think that's how he keeps this trial straight.
Just some slight language changes, I think is the most accurate description of whether or not they're going to have prejudice, bias, or opinions.
We can definitely service jurors.
I'm not quite sure what it means to say whose minds are not perfectly impartial. That's my objection.
Okay, so if we take a look at OCGA 15-12-164, those are 3 statutory questions that shall be asked in every felony case. So I really don't think there's any discretion whatsoever, and even messing with the language, I think, puts us in a dangerous territory.
All right, so if you want to see the judge getting upset, he's upset right now. You probably can't tell, but he's like, look, people, this is the language that's required by law. I'm not going to change it. You're going to need to deal with it. Oh my goodness, this judge. Can you get unemployment insurance for 5 months? I don't know. That's a great question. I'm not sure exactly how that unemployment would work if you are in a pause situation to serve on a jury. So that's a great question, though. Yeah, he's miffed. He's like, so right now they're going through the sets of proposed questions, and the judge has gone through the introductory paragraph, and then he's going through the first sets of questions that are all statutory questions. So they're just governed by law. These are normal questions. Everybody gets asked in all cases, and the defense has already asked for a piece of one of his questions to be deleted. This is the judge's question, okay? So he's like, well, we don't really like that language of Part C. And he's like, dude, chill out. Oh, my gosh. Yes, so they deleted, his first question had parts A, B, and C. And Part C had to do with not having a prejudiced mindset. And Powell's attorney didn't like the language, so asked for it to be struck. And so now the judge is just saying, look, people. So... the lawyers are testing the judge. I don't think they're necessarily testing the judge. I think they're just too self-involved to even think that way. I think they are so self-centered on their own, and I don't mean that in a negative way. I mean, they're so focused on their own person, on their own defense, on their own arguments, that the judge is just kind of in the way. And so they're going to do and say everything they need to do, whether the judge is there or not. So it's really not about the judge. It's about getting their own pieces that they want to get said out there into the world.
Literally every single felony case, we have to ask those in Georgia by code. And as the greater theme, because they're so broad in their application, as a preview to what comes next, generally when I'm reading the cases on this, those swallow a lot of the other more specific questions when we're talking about bias. At least that's how our appellate courts have looked at it, and we'll get into it. But so I'll overrule the objection on that, and we'll have all 3 of those statutory questions as laid out in the code.
Okay, so the judge just said, forget about it. Too bad. We're going to go with my questions. That's the law. Now we're moving on.
So this first section, Again, dealing with just general background. Based on the defendant's consolidated red line, I didn't see any further objections to the changes made by the state to the original drafts or the state's proposals. Anything else in that initial section which takes us through question 31 and leads us into case-specific questions? Okay.
No, Your Honor.
Okay, Mr. I would think that was Mr. Grubman for the record. Okay. Okay. So, moving into more of the meat of it, we've got case-specific questions, and the final defense red line asked to re-add what was in their original proposal, which would be, I'm just thinking for the record now what I should be referring to these as, since we've got multiple versions floating around. Let's see. Give me 1 second. I think this would be on Court's Exhibit 2, which is the original defense request. This would be questions 37 through 45. That's right. And on the red line provided by the defense, it's 32 through 39. And generally, this is questions about zeroing in on Sidney Powell, Kenneth Chesbro, asking, are they definitely guilty, probably not guilty? What is your opinion? Very positive, somewhat negative. Write in your own words your opinion. Would a defendant have a hard time convincing you they're not guilty of interfering in the results? Would you be less inclined to believe them compared to other witnesses?
Okay, hold on here. Can I ask, why is there only 2 defendants in this hearing? Sure, Dave. So what happened here, we've got 19 total. One's pled out. That left 18. Out of those 18, 2 of them requested a speedy trial. And that means the trials have to be done within a certain period of time. So Chesbro and Powell both requested, let me give you a visual aid here, both requested speedy. So this is their trial. Everybody else waived speedy or said, forget about it, we don't want to rush this. And so they will be set for a different time. But because they requested a speedy trial, which is their right in the Constitution, that's why we've got 2 of them.
And then it repeats those same questions for Mr. Chesbro. So the state had objected to that block of questions. And so, State, do you have anything you want to add to that objection?
We just think these are improper questions. They prejudge the case as for basically the jurors judge on hypotheticals without evidence.
I would agree with that. Now, you may have missed it here. I'm trying to kind of come in and out here with my commentary. I hope it's helpful, everybody. But basically, the defense has put in as a proposed question to say, basically poll the potential jurors. Again, we're looking at a group of 450 in the Venere. So this is way before we even start calling people in for voir dire. And so one of the questions they want to do is a polling question. Do you think that the defendant could be found guilty, maybe be found guilty, or not be found guilty? Those kinds of polling questions like that in a jury questionnaire is very prejudicial. And that's what the state is pointing out here. That's a technique that we use during voir dire in order to try to get the jurors already thinking to our side of the case, but it's not something that you're going to want to put into a jury questionnaire. Now, I've not seen what the judge will answer on this, but I would be very surprised if he allowed that kind of a polling question in those original. Yes, so we've got an original set of 450. 450, just let me double check that number. So the judge had set out in a hearing that how many jurors he would be pulling in. So we've got the original set of 450. And then if they can't find enough this week, another set of 450 will come in. Keep in mind what they're trying to do is whittle it down to a batch of, I don't know, maybe 75 total. And they'll start asking questions and then eliminating prospective jurors from there until they get that number that they're looking for, which is 12, I think, plus 2 alternates. Don't quote me on those specific numbers, but you have to start with this huge pool and then take it down day by day. So within 2 weeks, they will be seeing 900 potential jurors. And that's because they've got to try to find those impartial jurors. That's the key here.
And we'd actually ask for you to go back to our original submission, which asked if the opinion of the juror was, I believe, fixed and impartial.
Yes, they'll have different jurors for the next case. The next case will be at a very different time, which means the next venere will be a different group of people. The venere is just who in the community is possibly called for jury duty. So anyone who gets a letter that says you need to show up, that's the venere. And then when they get to the courtroom, they go through and ask this initial set of questions through this questionnaire. Some people are automatically eliminated because it's not appropriate. And then from that list, then we start the voir dire process.
Partial, fixing couldn't be changed.
Okay, I'd have to. I'm working off a couple different versions. So is it the same? You're saying there's a question where you essentially said, referring to Sidney Powell and Kenneth Chesbrough, is it so fixed indefinite?
Yes.
All right, and why would that not be covered by 2A through C, the statutory questions?
It would be. It just asks again. It would be good.
Okay, so one of my goals with the questionnaire is if a question's already asked, not to ask it again. So we want to keep things streamlined, and so repetition or a duplicative question is going to be one that's probably going to get the axe from me. Okay, from the defense, this block of questions.
Yeah, with respect to our edits, the first edit we suggested is striking 32A, which read, if yes, is any of the information impaired your ability to be fair and impartial with regards to Sidney Powell and Kenneth Chesbrough. We've asked that question be removed because our concern is that most people are going to want to say that they can be fair and impartial. When they're asked that question, their instinct is always going to be, well, I want to say that I can be fair and impartial. And sometimes the answer may not necessarily be an accurate reflection of what they think. And just as an example, we made this similar change with respect to question 87, where I think we struck that may affect your ability to be fair and impartial as it relates to their opinions regarding District Attorney Fonnie Willis. Our thinking on both edits is, let's just, if we can, just ask them what their opinions are of the folks, because that more likely will draw out people's responses that will reflect if, in fact, they can be fair and impartial, as opposed to just flatly asking them that. I think there's a whole lot of sociological studies and cases that have, sort of looked at this. People answer questions the way they think they should answer them, and everybody wants to believe they can.
So I'm going to pause for a moment. All right. So this is Sidney Powell's attorney. He's practices a lot in federal court. He's in Georgia. This isn't his home turf. But if you look at him while he's basically trying to school the judge is like, I have been presiding over a ton of jury trials. So why don't you go ahead and tell me about how to ask the questions? So you can kind of see that the judge is like, oh, for goodness sake. He's letting him go because, of course, they're making a record, all of this. But this attorney is like, well, they might not be completely truthful. Like, you think? like we all went to law school. We all know what's happening here. But meanwhile, the judge is like, fine, just hurry up with what you're saying. Let's move on. I mean, he's like, let's get this done. But, these attorneys are like, all right, well, whatever.
Fair and impartial. And we think that if you just ask them, what is your opinion about Sidney Powell, Kenneth Chesbrough, or District Attorney Willis, I think people are going to honestly answer, and that answer will be the real reflection of whether or not we as a collective can decide if they can be fair and impartial. So that is our thinking with respect to that. And as it relates to the remaining questions on the edited one, which I think are 33 through 39, you mentioned, we just believe that
80 questions is a lot. Linda, that's a good point. I think 80 is a lot, but there's just a lot of complicating factors in this case, especially because it's a RICO case. We've got 161 acts, and then we have all the rest of the counts. So we've got 40 further counts. There's a lot of complexities when it comes to conspiracy kinds of questions, and so they're really going to need to explain those kinds of things out just a little bit in the questionnaire. So 80 does seem like a lot, but I think it's kind of needed in this type of a case. Yeah, it is. It is being shown on YouTube, but I am behind, so we're watching the recorded to live version. We're about an hour behind it, so if you want to go and watch it live, you can go onto YouTube.
Given the high-profile nature of this case and the amount of media publicity and saturation that's out there, asking some questions about their opinions about the two defendants on trial, getting their attitudes about them generally, as we've tried to reflect here, is the best way for us to ensure on the defense side that we're going to get a fair and impartial jury. We just want to hear what folks think. And if they have no opinion or unsure who they are, we'll have a better sense.
Look at this judge.
He's like, particularly as it relates to Ms. Powell, we want to hear about those attitudes and opinions, and we think the questions we've asked would draw those kinds of things out, which would best ensure that we're going to get a fair and impartial jury in this case.
So I put all of my lives up. I do put all of my lives up on my Tube of You channel. So I'm about 2 lives behind everybody, but I will have this up. Yeah, and I know a lot of people, don't have time to watch it, so I do try to put these back up. And as we continue to get closer to the trial, we'll be doing more of these kinds of, watch party styles, because there is a lot of stuff that they're talking about that people don't understand. I don't know how anyone would understand some of the things that they're talking about with the venere and different pieces of the statute. So I'm absolutely happy to come in and have people listen to me, or else I'd just be talking to myself. So so I will definitely have this up on my Tube of You channel. So
May I reply, Your Honor?
Oh, well, I think Mr. Aurora might have something to add as well.
And Your Honor, the reason I think I talked to Mr. Rafferty about those questions is, depending on how many of the 14 we have in that 1 hour, it may sort of point us to getting to that question quicker rather than sort of, talking in circles around each individual juror, wasting a little bit of time. It gets us there. Plus, I wanted to focus in on 37 and 39 on the working copy. I think we've been allowed to ask, if you consider like a police officer more credible than somebody else. So I think 37 and 39 at a minimum are good. The others, I'll adopt Mr. Rafferty's argument, but also say it helps us sort of tailor our individual voir dire since we're on a time clock.
Yeah, just a moment. I'll say at a minimum, 32 B and C as on this red line, which in the original defense submissions would be question 37 and 41. I think those absolutely go to prejudgment when you're asking whether someone's probably guilty of interfering in Georgia election results. So I don't think there's any question that those are out. But the idea of just basically what is your opinion of the defendant? Positive, negative, neutral, or unsure. Again, not something I've typically seen here, where we just say, what do you think of that person over there? But counsel contends that due to the media attention, perhaps that would be enlightening here. So, Mr. Burnett, or Mr. Rafferty?
That is my point, Your Honor. Your typical case where a defendant...
Okay, I'm pausing again. So this attorney, the judge was asking the state what their opinion was on it, which he has to do. And then this attorney is coming back in and re-arguing everything that he just argued about this question. And the judge is like, look, I just need to get the other side's perspective on it. So very interesting. Hello, VC. Welcome.
And is charged with a murder, robbery, whatever it is. Most folks don't know anything about that person. And so asking them their opinion of that defendant on trial,
he's
really
not amused, no.
Much. But in this particular case, given how much national media coverage has covered everything to do with this case and the individuals. Now, they may not know Mr. Chesborough, they may not know Ms. Powell, but there are probably a lot of folks who do, who follow the media, who follow January 6th proceedings, who have opinions. And if they've formed opinions about our clients, I think that's going to lend itself to some questioning, as Mr. Aurora said, during our individual voir dire that might tease out whether those folks can be fair and impartial.
But you'd agree that itself is not going to be a disqualifying factor, someone having an opinion of your client.
Right.
Not necessarily, Your Honor, but if somebody has an opinion of my client and they express an opinion that's extremely favorable or extremely unfavorable, I think that is going to lead to questioning of the jurors in that very narrow window.
Okay, pausing. VC, yes, Judge Chutkin, the gag order hearing is going on in D.C. right now. So we don't have access to that, but I also am really curious about what's going to happen. So just for anyone else who's interested, we do have that protective order request hearing contested today.
Of time that we have that would let us better understand if that particular jury.
Yeah, he's getting upset.
Mr. Rennick?
Yeah. Going over the 34 and 35 of the red line version of the defendant's, your opinion. Again, I think that goes back to prejudgment of the case. It's asking you to assume hypotheticals about what they've heard and what's their opinion of that, and start forming conclusions about it. And I'm going back to Anderson v. State. That's 309 Georgia 618, a 2020 Georgia Supreme Court case. Generally speaking, prejudgment questions that require a prospective juror to assume facts that are not yet proved and to prejudge the case based on those assumed facts are inappropriate. And then going back to, based on what I have heard or read, I'd be less inclined to believe Sidney Powell and I believe the other one, Dr. Kenneth Chesbrough. I think that goes to judging credibility.
So what's your position, though? Because I think it does correspond to the question we see a lot of law enforcement officer. Would you be more inclined to believe them solely on their law enforcement status?
That goes to, I believe that also goes to credibility. And actually, trial courts are found to be, it's appropriate when trial courts refuse to allow that question.
No, I know that. Was that one, I forget whether the state objected to or was the defense request on that question?
We also don't have any police officers in the case. They're going to future. Well, we do. We don't. They're not the substantive.
I repost them onto my Tube of You channel.
That question, where that one, I think that came from the defense, actually, didn't it? Okay.
So what's happening here, the state is saying their piece, and they're saying, we think that this question's important. The judge, meanwhile, just like with a scalpel, is trying to carve away at what he needs in order to get a legal ruling. So he's asking the state, well, I know the case you're talking about. I'm asking, did you object or did you not object? And the state's like, what? And he's like, oh, for goodness sake.
All right, anything else, Mr. Vernon? Was there anything else?
No, Your Honor, sorry.
Okay. Yeah, so again, on like 36 and 37, given what you've seen or heard, they have a hard time convincing you. I think that absolutely does get into prejudgment. Best fitting your opinion? I mean, obviously, I guess when we're asking about where does someone get an opinion, most likely here is going to be from the news, but I think that question could also be used to draw out. I'm just trying to think if it was in any other case, someone's opinion could be based on personal interactions or personal knowledge or relationships of some kind, and maybe here those questions will be helpful in narrowing our focus when it comes to individual voir dire. So well, I think I would leave in, I could re-add 34 and 35, just asking for a general opinion of each defendant. I would think that the remainder of these do start crossing the line and getting into prejudgment and legal issues, and frankly, if the only reason we'd be bringing in the less inclined to believe a particular defendant compared to other witnesses is because the law enforcement question is there, I'd say we strike the law enforcement question as well.
So, based on the working copy,
Hold on. I'm going to make a note here. All right, with Mr. I believe this is Mr. Not Lemonade, whom is my least favorite so far. He is not standing. He is addressing the judge, and it's getting very frustrating to me. I just don't know why this attorney, for some reason, just drives me bonkers.
on 32A, 34.
No, not 32A. That's calling for prejudgment. It would just be 34 and 35, asking for an opinion of Ms. Powell and asking for an opinion of Ms. Chesbrough, the boxes.
Cutting out the less inclined 37 and 39, is that correct, John?
That's right.
You should stand when you address the judge.
Yeah, 33, I think having an open-ended question, I think that's something more appropriate for the individual voir dire. Again, what I'm also trying to keep in mind here is that just because it's struck from the questionnaire doesn't mean it's foreclosed from going into
that guy there.
Individual questioning. I think it's more just we're asking overall whether we think there's anything outright that shows bias or a fixed opinion, And I don't think we need to keep re-asking that question a dozen different ways, on the questionnaire at least. Okay. Question 41 on the working copy, which is...
I agree, Neil. I think this judge really
Anxious, that's question 46
picks his
on
battles
Court's
carefully.
Exhibit 2. Assume you were a juror in this case. Would you feel nervous or anxious about returning any verdict out of concern for how the public might respond? My thought there was to combine that in some manner with...
Oh, Heather, he has stood every single time he has addressed the judge, except for now. So I do not see any kind of disability, even hidden or not hidden, where he doesn't have the ability to stand.
Previous question. I'm fine with including it, the general subject, into the questionnaire, just to see if that's something... I don't know if that's necessarily going to be disqualifying, but it may be something that the parties contend is relevant for their preemptories. But I'll hear any thoughts from either side.
We're okay for it, just to clarify for the record. When we,
See, there he is, standing. That's what you're supposed to do.
said we objected. We just objected to it, saying returning a not guilty verdict, I believe, was the defense said. And we twisted to any...
I'm not sure if he's trying to be disrespectful intentionally. I think it's more of that self-centeredness again, where he's so focused on getting his question out and his question asked that he's not realizing that he's not even doing the basic courtesy that you would do for a judge in a case like this.
So we're okay with any verdict.
Okay.
Government's okay with the question as is?
Yes. Okay.
So can we figure out a way to combine 40 and 41? Because I think they're essentially getting to the same thing. One is asking pressure from members of the community, and the other is asking about concern of how the public might respond. And it's essentially the same question, just phrased a little differently. So if you want to figure out a way to combine it, or you want one or the other, otherwise, trying to stay streamlined here.
I guess if everyone...
Oh my God, he's not standing again.
It might be easier to cut 40 since 41 sort of talks about it. If everyone else is okay with it, that might solve your problem instead of doing a compound question.
Okay. Do we want to flip it then and say 41 comes in and 40 goes out? Let's do that.
Can that courtesy or lack of affect the judge's decision? Well, it certainly doesn't help you. You know, again, you've got to keep in mind, this is the judge's house. And so if you've got the host here and there are certain rules that they request, like take your shoes off, you know, and he's not, like, that's just kind of one of those things that you're, you know, kind of setting it on the wrong note. But also, this guy, Mr. Not Lemonade, repeatedly has been doing all kinds of stuff here that's very frustrating. And this judge continues to knock him back. This was the guy that he referred to, Judge McAfee referred to in his order by saying the Monty Python reference of saying, you know, the bird's dead. It's dead. The parrot's dead. And he was referring to this attorney who keeps bringing up these issues. Deliberate. It could be. I do try to look, you know, give them the benefit of the doubt. Yeah, no, it's absolutely disrespectful. And I think I even saw Mr. Lemonade kind of give him this hand motion to say, you know, stand up. But yeah, I think the judge, again, is picking his battles. But if you, as the judge, have to say, you know, you need to stand, counsel, that's already wasted words and wasted time. So I would say at this point, it's just showing blatant disrespect, true. But is it intentional disrespect? That I don't know. Will the judge say something? I'm not sure. It depends on how much it bothers him.
Okay, moving on. I didn't see any... I think I remember the state may have objected to asking whether they'd watched any of a particular press conference or...
I think it was just the form again.
Okay.
They're really dealing on these. We just said the November 19th.
So are we satisfied now with how it's phrased?
You are satisfied.
Okay.
What questions were you...
I was talking more about in the working copy 45 through 49, where we start talking about specific incidents alleged as overt acts in the indictment, like the November 19th press conference, Georgia legislative hearings. I remember the state had lodged an objection to one of those, and I was just inquiring about that. But it sounds like that's been resolved through this latest copy. All right, getting back to, I think it was the defense's major contention with the current working copy, and let me find where this is in the original submission.
It could be. It could very well be intentional. I know that I'm biased against Mr. Not Lemonade, so I'm hesitant.
It's starting with 51 on the working copy. I don't know if I can find it, but I'll just try to describe it as we go along. So the first question is, have you ever talked about the charges against Donald Trump, this case, or the events with your family, friends, coworkers on social media? The next question was, have you ever heard others talking about the charges against Donald Trump, this case, and events online? To me, that...
Just as a quick side note, someone said that they'd get tired of standing and sitting. You're right. You're right. My knees could not take all this sit and stand. You know, that's a really good point. But I tell you, when you are in trial and you're in court all the time, you don't even know you're doing it. It's a reflex. If you're talking to the judge, you stand. When you're done, you sit back down. If you have something to say, you stand again. Like you don't even think about it. It just becomes part of human nature. And in fact, even in chambers, sometimes you forget and the judge will be like, hey, take a seat. You don't need to stand. We're in chambers. Like, whoops, I forgot.
That question had already been covered by, I think we had a section on media habits where we ask a pretty open-ended question about what have you heard about this case? And or maybe that was before. Yeah, on question 42, have you read, seen, or heard about the alleged interference in the 2020 election results? And we basically leave it completely open-ended. So to me, those two questions were just re-asking what we'd already covered. Any thoughts from either side? This is on copy 51, 52.
You are going to be asking question 50.
See, he stood just for a simple
I
question.
didn't see an objection from either side about that.
Chesbro, the court thinks 42 is redundant. 52 is okay. I think 52 reasonable court can save action.
Right. That was what I was also going to say is we're really just supposed to be focused on the jurors themselves and start asking what their people have told them. Now we're just opening up a whole new line of inquiry that I think is more of a distraction and not really all that relevant. Okay, so not having heard anything, 51, 52 will stay out. And then we get into kind of what looks more like a gallop. Oh, sorry.
Hold on. All right. Now, both of his attorneys are having a convo here. Let's see what's going on.
51 is in, right, Your Honor?
No. I was saying both of those are covered by the discussion of what have you heard about this case?
Well,
Oh, I'm sorry. When you say you ever talked about the charges with family or members? Okay. No, I'm sorry. I see what you mean. All right. So 52 stays out, but you're talking about 51. Have you ever talked about the charges with your family, friends, or coworkers, or discussed it online? Okay. Again, let me review what we have, but I think that was already covered by the case or media habits. Let me just make sure.
No, Your Honor. Question 50 and question 51 are awfully close.
Right.
Those two questions, it says, have you posted anything online in 50? And 51 is, have you ever talked about it?
There you go.
Is there a way, if we can combine those two questions, some of the language from 51 into 50?
I think that makes sense. That's probably what I was trying to look for, is the immediately preceding question.
And we're good with combining the two questions.
All right, so Mr. Voir or Mr. Grumman, how would you propose combining those?
My suggestion maybe would be, have you ever talked about charges against Donald Trump, posted anything online, or reposted anything online about charges against Donald Trump, this case, or these events in person or online?
we're good with that.
So make sure I heard that right. Have you ever talked about or posted anything online?
Yes.
Okay. Any thoughts from the state?
That's fine.
Okay.
Good with it.
Okay, so then 50 will go in with those edits, and 51 and 52 as proposed in the working copy stay out. moving on, we get to, on the working copy, 5354. And this kind of takes the form of almost like a Gallup poll where we list 20-something individuals, including all the defendants, and what looks to be potential state's witnesses, and asking your opinion of the following individuals: favorable, somewhat unfavorable, no opinion, somewhat favorable, very favorable. So I believe the state objected to this, and let me start with you, Mr. Pernick.
Yes, we don't think these are relevant in this case. They asked about other co-defendants. They're not on trial yet, so we don't believe this is actually relevant to the case at hand.
Okay. Mr. Rafferty?
I guess, my response, Your Honor, is the government has indicated its intention to prove its entire case over the course of 6 months about all the defendants in this case. And as I've said for over a month now, that has nothing to do with Sidney Powell. And so if the government's intention is to...
Is it fair to say these first trials will set the tone for the RICO cases of others? Yes, I think so. I think anytime you go through a process, you learn from it, and then you do better on the next one. And I think someone asked, too, if the 16 remaining defendants would be tried together. I'm getting the feeling from Judge McAfee when he has been talking about this that he could split that into 2 or more trials, is how he's put it. I'd be surprised if it was more than 2 trials, but he has discussed the fact that he thinks it would be hard to have this number of defendants in a courtroom and put on a full case. So those kinds of questions have already been brought up. They are something that he is thinking about. How many questions are generally allowed? Well, right now they're talking about the initial jury questionnaire, so it really depends on your jurisdiction. Some jurisdictions could have 20 questions, some could have 50 questions. In a complicated case like this, it's making sense to have quite a bit more. The big issue that they're talking about for this specific question is that they're asking to list all the other defendants that are not on trial, along with a whole bunch of witnesses the state is going to call, and ask if the potential jurors, so the venere, finds, guilty, not guilty, undecided. And the state is saying that's completely inappropriate here. We can ask those kinds of questions when we're doing voir dire, but to put it in a jury questionnaire is not appropriate. And now Ms. Powell's attorney is arguing why he believes it's appropriate. 16 rounds of objections. Exactly, VC, exactly. Yeah, it would be a lot. It would just be, it's just not practicable. It would be an issue for sure. It would take years. I know. So, we'll see. I think this case will tell everybody quite a bit. It'll also give the remaining defendants a chance to decide if they want to plead it out. Who pays for all this court time? Well, who do you think pays for it? Feel like an attorney after all this. That's great. Go for it.
To offer up a lot of information about President Trump, Rudy Giuliani, John Eastman, that has nothing to do with my client. I think we would ask that the court ask the jurors about their opinions about these various individuals and whether or not they have particularly favorable or unfavorable views of them, because I think it will lend itself to a dialogue with these jurors that might result in a fair and impartial jury for both sides. Since we're under a time crunch, asking them if they already have these opinions would really help us move along, I think, the questioning when we come to individual. And that's the reason why we ask about 53.
I have to say, I don't really agree with the arguments that Ms. Powell's attorney is making, but he's just so professional. He's extremely professional in how he's presenting his arguments, his questions. He's backing it up with legitimate rationale. So I can appreciate his style, even though the content is not something I agree with on this particular question. But I think he's doing an excellent job as an attorney. I would not say that about Mr. Not Lemonade. He's bothering me.
Then once again about 54, because even though the 54 are not defendants in the case, these are identified and very high-profile and public witnesses that the government has expressed an intention to call at this trial. And we would ask for the same reason to know if folks have particularly strong opinions one way or the other about those folks.
Before Mr. Rohr responds here, that brings something to mind is, do we think it might be necessary in the background section to list all of the co-defendants so that the jurors are aware of...
Okay, if you're looking at evidence, opinions should not matter. I agree with that. I absolutely agree with that. I think that is very important. But I have to say, if somebody gives you a piece of evidence, like if they're giving you a sandwich on a plate and they shove it in your face versus just nicely passing it to you, it's a little different. You may have a little different thought about that bologna sandwich. It's still a sandwich, but if somebody throws it at you versus nicely hands it to you, very different.
Of who else has been charged and who else is probably going to be talked about. So that when they're asked generally, do you have any bias? Have you heard anything? They also are aware of these other names.
That would be, Your Honor, in the background right before it says jury service on page.
Right. In the opening where we're saying 19 others or 18 others, we could say include.
No, his name is not Lemonade, but I'm not here to promote anybody's law firm. So it's for safety as well as, I'm not here endorsing anybody. So I think it's okay to have little nicknames.
Including, and then list them.
I can go both ways, absolutely.
Why would we be redacting the indictment at this point?
I mean, we'll get to that. I mean, that's for way down the road when the jury would ever actually see the indictment.
But still, I mean, we're redacting the
Right.
for a reason.
Worth flagging. Any thoughts there, Mr. Rafferty?
On why we would redact?
No. Just including the names of the other co-defendants in the background section, since you're saying that the jurors need to be on notice.
I think, Your Honor, it probably does make sense in that introductory section for those other individuals, particularly some of the names that everybody seems to know, to have them listed. So I tend to agree with the court that we should have all 19 defendants listed in the background section.
Okay.
She's the court reporter.
All right. And now, Mr. Brennan.
And then
Yeah.
also, I
So,
think
yes.
53 will be duplicative of number 50 anyway. Where you're especially if we add the.
Yeah, we'll get back to that. I'm trying to go through each issue at a time. Mr. Voir, any thoughts on adding co-defendants to the background section?
Fine, I think Mr. Rafferty's points made. It just keeps it clear.
Look at that. Look at the judge sitting back and acknowledging how disrespectful this attorney is for not standing. He's getting more and more frustrated. I would not be surprised if he does actually say something. I'd be very surprised about that. It's just, there's no excuse for it. I mean, if you forget a couple of times, that's one thing. But if you forget all the time, it means you have no trial experience. You're not used to actually following the rules, or you're intentionally being rude and disrespectful.
And my biggest concern in asking some of these questions is just to keep the individual radar going so I can sort of see off the sheet who said what, so I don't generically ask that and waste 2 minutes for them, contemplating what they're thinking on the spot. I've already got it. So it's not that we're trying to get into it, but you and I both know we're going to ask about it. So this just speeds it along for us to see who did.
Even his language is rude. Like you and I both know, like he's saying, hey, we're the same. It doesn't matter that you're the judge. We're the same here. We're just lawyers trying to work on this case together. I mean, that's incredibly rude. That is a huge sign of disrespect. You would never say that to a judge. You know what I mean, Your Honor? You and I both agree. Like, no, the judge doesn't agree with anything you say. That's not how judges work.
What? So we can directly go to those questions of the individual versus just, you understand, being very general and vague about it, digging that way. Because even if there's only 8 or 9 people, that leaves us like maybe 6-7 minutes. I don't want to waste 2 minutes getting there, because you understand these are household names and people are going to know.
So, no, there's no doubt that all the names listed that we're asking for opinions on are well known, and likely the folks do have opinions on them. The bridge I'm not crossing here or not yet seeing is how an opinion on a witness is going to necessarily play into a fixed and definite opinion on the case at issue. Whether we can find a juror that's fair and impartial is the ultimate question. And so how they feel about a particular witness, I mean, unless you're saying that we should ask this about every single, which essentially they're going to get the witness list at the very end of this where they're saying, do you know it?
Daisy, that's very wise. That's exactly what happens. And sometimes it happens. Sometimes counsel forgets to stand up, especially if you're not in trial very often. And, most criminal defendants, you plead your cases out. You don't take it to trial. But a judge could very well say, who is talking? Or, please stand so that the court reporter can see who's talking. I mean, there's all kinds of things. Because you can tell just by watching this how hard it is to figure out who's actually asking the question because he's not standing up. So not only is it disrespectful, but it's actually a procedural issue too, to create this record. Now, judge is saying, look, what are you talking about? Repeatedly to this guy. And it's becoming very frustrating. And, this seems to be the trend with this guy. And, again, I've got a little bit of bias, but it's also very frustrating to watch. I have looked up these attorneys' backgrounds, and he does have more of an academic background. So I'm not sure if perhaps his ego is just too huge or what's going on. But this attorney, Cheesebro's other attorney, has actually worked cases with him when Judge McAfee was an attorney. So I'm not as concerned about him. But this guy, no, he's I'm not sure about him.
Any of these people, we could tailor that to say, do any of these, people provoke any reaction in you or affect your ability to be fair and impartial? But to kind of run an opinion poll and highlight certain ones of them, that's giving me some pause.
Well, on 53, I just meant the defendants first. I think that's something we have to get into. On 54, if it's giving Your Honor pause, we can just wrap it up into is the state's witness more credible than the others that we ask all the time in the regular cases, and sort of just generically cover it in a more vague manner than listing possibly every witness that's high profile. My bigger concern is 53 with the defendants themselves, because if they're proving the full conspiracy, the names are going to come up whether it's redacted or not. And so I just want to be...
Well, what about instead of, a Gallup poll listing every single one of them, it's more of a catch-all question of, you've heard the names of the other co-defendants. Does that affect your opinion and your ability to consider Mr. Chesbro and Ms. Powell? I think something along those lines that we're getting better.
Right, and depending on if they say yes or no, then we start probing in. I just thought that this would make it easier to follow versus me asking those questions, which I will be asking individually. So it just sort of maybe cuts to the meat of the matter, because everybody's going to say they have an opinion, right? Unless you just don't watch the news. And then we ask all 19 of these questions individually versus, maybe they say no opinion, and we can just skip through some of them instead of repeating ourselves 14 times.
Okay, let me go. I know Mr. Rafferty, and then I'll go back to the state. Any thoughts, sir?
Well, Your Honor, if the idea is that you would, for question 53, you've heard all the defendants in this case, if we could still just have them listed just so we know that the folks are actually looking at the names so that they're not just flipping through the thing and trying to get through it, so that you don't want to have the very unfavorable to very favorable sort of range. At least, what are your opinions of the following defendants? Just have their names and put a line at the end what their response is. That's what I would ask for, at least, so we know what folks are thinking. Which I think is what you were suggesting, just not repeating all their names. And as it relates to the other question, 54, my thinking is I've tried to identify some of the extremely high-profile folks that are on the government's witness list, beginning with the governor, Alex Jones, Steve Bannon, Michael Flynn. These are very high-profile names that have been in the media. And, I don't know what folks' opinions are, if they have any. But my thinking is, not every witness needs to be on there, but some of the folks that have been in the media most frequently that people are going to know, I'd be interested if they have any opinions about any of it. That's just my view.
Okay. And thoughts from the state?
Okay. Again, we think this is going to be duplicative of the question, have you heard or read or seen anything in the media about the following defendants or the case? And, their opinion about other co-defendants that are not on trial, I don't think that's going to get us into an inquiry or get us very far into whether their opinion is fixed and determine that they cannot be fair and impartial against these defendants themselves. And then going to 54 about the witnesses.
I think if it bothered him, he would say something, but he also has to prioritize. This is so adversarial. Just these basic questions where they're saying, we don't even want the statutory questions on the questionnaire. He's like, oh my gosh, let's kind of get to what the real issues are, as opposed to saying, wow, you're extremely disrespectful. Another thing too that, somebody had raised was, if this guy, here had a disability and couldn't stand. And, there are many times where we have attorneys who do have disabilities that can't stand. And that's something that's settled ahead of time, and something also that can be put on the record just so that it's clarified for anybody. So I've seen that before, where a judge has said, defense counsel, who has had a broken leg or something like that will not be standing, and then just clarifying that with the court reporter again. So there are ways to accommodate that, but I don't see any of that occurring here. So, that's why I think there's some good questions about it.
Here, again, it's not appropriate. It's kind of like a question,
Statutorial questions are questions required to be asked on a jury questionnaire according to statute for this particular crime.
They're kind of saying it also includes, persons on both sides of the spectrum, and who do you believe more? You're kind of asking for people whose credibility do you think is more credible. And that's kind of like a question in Henderson v. State, 251, Georgia 398, that prohibited questions regarding the credibility of law enforcement officers.
Perry, yes, very true. Very true. There are many with disabilities, and you still stand. Myself, I have my own story. I had a particular day where I was unable to stand, and it was just awful. In fact, I had to stop myself from standing. I had a sprained ankle, and so I couldn't stand during the hearing. And I had explained it to the judge and counsel in chambers beforehand. The judge was like, "Don't worry about it. It's fine. It's just, it's just a hearing." But I had to stop myself. I had a paralegal with me who just would be like, don't stand, because it's just a reflex to stand. This is the government's table over here. All right. This is Powell's attorney, his assistant, I believe his assistant. This is Mr. Not Lemonade, Mr. Lemonade, and their assistant. And these guys are Cheese Bro. This one's Powell. This is the state. Yeah, well, right. I mean, Jennifer, we don't know. It's possible. It's just he has, in all the other hearings, always stood up every time he's asked a question. He has not done this before. When he's presented arguments, he's always stood. When he's asked questions, he's always stood. We've had all kinds of hearings where he's been up and down and up and down. So this is unusual behavior. That's why I think, that's kind of why I'm pointing it out, because I haven't seen this before from this attorney. No, this is not funny here. These are the state's assistant DAs here. Oh, you bet, Jennifer.
Ordinary citizens.
All right. Well, when it comes to highlighting specific witnesses, I think that if defense counsel wants to use their time during individual voir dire, just to particularly relevant to the ultimate question of the impartiality of the juror. And so I would not add 54. 53, I'll take a look at that to see if it won't come in the form of the boxes, but if we need to add a question referring generally to the other co-defendants, because defense counsel want to explore that. Again, I think it's probably going to be irrelevant to the fixed and definite opinion for the particular defendants on trial. But if that's something...
How long does it take usually to get through? Well, right now they're talking about a actual handout that they're going to be giving to the jurors, that the jurors will fill out. They will write all of their answers in. So that's this initial first set of questions that they're going to be asking the jurors. So the jurors come in on Friday. Everyone's given this questionnaire. They have to fill it out and then turn it back in. Then all of that information will be entered into a database. And then from there, they will start eliminating and then going through the voir dire process once the elimination has occurred. So that's how this whole process is working. Oh, it's time to read all the info. Yeah, that's a good question. Oh my goodness. Yes. Excellent. Thank you for... Oh, you're welcome. I'm hoping it's helpful, at least a little bit. Even with my bias against Mr. Not Lemonade. I'm confused with the lemonade. Okay, I apologize, everybody. Listen, so this dude here, this dude, We call him Mr. Lemonade because of his pronunciation of a motion in limine during one of his first hearings. All right, so he's Mr. Lemonade, Cheesebro's first attorney, and this is Mr. Not Lemonade because he clearly is not lemonade. So that's his second attorney. Now, this is Miss Powell's attorney. Again, Mr. Cheesebro has two, so we've got Lemonade, Not Lemonade, and then we have Miss Powell's attorney. I'm not really promoting anybody's business, so I think it's okay to have different names. And then these are all of the district attorneys here. Oh, my goodness.
Then they want to explore for their preemptories, I suppose. I don't think that's unreasonable. It's more the form of it that gives me pause. So
it depends on your jurisdiction, Jennifer. Usually the initial questionnaires, like in my jurisdiction, will actually be sent to the venere. So all the potential jurors will have a questionnaire online that they need to fill out, and then they submit it. And then from those submissions, everybody, both sides can go through and look at all of the information. So it's actually done online. This one, it looks like they're doing it by hand with paper, and then going through and entering it. So it depends on your jurisdiction. But this is the very, very first set of questions that the original venere, so anybody who could possibly be called in, has to fill this out. From there, we'll eliminate a whole bunch of people and then keep eliminating until we get a decent size jury pool. And then from there, actually pick the jury.
I'll take a look at that one and see how we can adjust it.
Oh, you're welcome, Neil.
Moving on in the questionnaire, the next point of contention I see brings us to the working copy 87, which is, do you have any opinion, either negative or positive, about the district attorney? The state had added in the qualifier that may affect your ability to be fair and impartial.
That's a very typical question.
As I said, Your Honor, our thinking was similar to our thinking with respect to 32. Just ask them what their opinion is more likely to produce, we think, honest information from the folks in a positive or negative light that they might have, as opposed to asking them whether they can be fair and impartial. Because as we said, I think all the studies show everybody wants to believe. We all want to believe we can be fair and impartial. But if they just offer their opinions, I think we're all in a better position to know if, based on what they say, they can in fact be fair and impartial. So that's our only thinking, and I think that's the reason why we made the same change that we made to 32 that we make here.
Okay. Anything else, Mr. Aurora? Okay. From the state?
Their opinion about the general opinion of the district attorney has nothing to do with this case here, we believe. So, strike it or keep it as, does it relate to you being fair and impartial here? I think that's the appropriate question that should be asked.
Right. I think we've been going, it's very much a fine line between jumping back and forth between opinions generally and opinions that reach the qualification of the juror.
I don't see any defendants.
Again, I'm trying to recognize that this is a case where these opinions may play into consideration here. So I'll consider 87. I'm inclined to keep in the fair and impartial language, but I'll think it over.
This is it. This is the questionnaire hearing.
There was a following segment where the defense wanted to add in.
So there's a question, who are these people back here? These are probably, I'm assuming a couple of these might be attorneys for the other defendants. A couple of them may be, but most likely these are all the support staff for these attorneys. So you probably have paralegals back here, legal assistants back here. Anybody who is assisting on this case are probably back here. And there could actually be some court personnel or clerk's office people as well, sitting and just kind of observing. But these are going to be any of the support people for these attorneys here in the front. Right. Oh, yeah, sure.
We had general statements talking about various issues that are likely to come up during the trial and asking whether they just generally their feelings on these statements. And the defense wanted to add in a couple more. I was already a bit kind of wary about the 5 that had made it in. But my initial reaction to these additions, which is defense going in order, I think that Trump and his associates tried to steal the election and throw out my vote. To me, that calls for a legal question. The next following, I think the First Amendment should not protect people who spread political and misinformation about elections. Again, I think that calls for a legal opinion. I think every single person who is accused of helping Donald Trump try to overturn the election should be punished to the fullest extent of the law. To me, that calls for prejudgment. And there's a final one. There's another one. Again, I don't remember who, I guess it's the defense adding this in. I think MAGA Republicans are mostly made up of radicals and white supremacists. I'll hear argument on that. And then finally, I think anyone who publicly claimed that the 2020 election was stolen from Donald Trump is guilty of spreading misinformation that undermines our democracy.
These are questions all being proposed by defense counsel. He's going through them one by one to see which ones are appropriate or not and clarifying which ones he'll hear arguments on and which ones are just going to be tossed.
And again, that to me very much seems like prejudgment and legal opinion here. So setting that all up, thoughts, reactions from both sides. Mr. Burdick.
Okay, I'll go first. We think the questions that they added back in are, as you noted, prejudgment. They're basically testing the defense theories here, getting a shot at seeing what the jurors are going to be receptive to before actually putting on their case and their argument.
Were any of those first 5 that were in this draft, were any of those the ones proposed by the state?
No, we actually objected to this whole section, Your Honor. I think you're thinking about the giving money to PACs and stuff like that.
Okay. So just generally, you think that this entire section was calling for prejudgment? Okay. Who? Anyone from the defense want to go first? Mr. Rafferty.
What I would say with respect to proposed F, G, H, I, and J, similar to what we said originally about attitudes. I think if folks express responses to these about their
is the state just being nice or is this standard? This is pretty standard. I think the state, much like the judge, they've probably got, 500 cases that they're working on right now. So although this is a huge case and probably the biggest case by far, they've got stuff to do. And so they're like, let's get in, let's get it sorted, let's get it out. Meanwhile, these guys, maybe this guy here, he seems like he's a criminal trial attorney, but these guys here, they just don't have the case numbers. They don't have that many cases. So they're able to kind of lollygag their way through all of this, nitpicking and so on. But meanwhile, this judge and the DAs and probably this guy here who's like, I got stuff to do, are all like, dude, let's move it along. So I would say it's pretty normal for the state to be at this point. And they're asking a really good question. The state's saying this is all prejudgment, which it is, which the judge has already explained. And so now we're going to see how these attorneys that, really don't spend that much time in trial. I'm not saying they're not good attorneys. I'm just saying they don't spend that much time in trial, as most attorneys don't. We'll see what their arguments are for trying to keep those questions in.
attitudes. They might have already said that they can be fair and impartial, but if we get that sort of information from them, we can better test whether in fact they can be fair and impartial. People are strongly agreeing that Trump and his associates tried to steal the election and throw out my vote. That's a person that I would have real concerns about, and the same would be true of G, H, I, and J. These are attitudinal type questions that we feel would bring out responses that would be able we would be able to use to test whether or not they can in fact be fair and impartial.
It's a lot of prejudgment questions.
I don't know if you're a stickler to the stick to one.
Not standing.
No, I don't care at all in this format.
Oh.
These are issues. In
Okay.
a normal case, I could see why this wouldn't be.
He's redeemed himself. I was getting concerned. Sometimes that can happen. When one attorney doesn't stand, it sets a precedent, and then other attorneys start to follow suit, and then you get a whole batch of attorneys who are being disrespectful. So I was about to have a fit over this guy, Mr. Lemonade, but he did finally stand, so he's redeemed himself.
This would be questionable. These are the issues in the case. So, for example, I think Trump and his associates tried to steal the election and throw out my vote. Literally, that is why we're here. I see Mr. Wade shaking his head, smiling.
Well, there's no question that's why we're here, but we always had a hard line in the sand about we're not going to come in here and ask you, do you think he's guilty or not? We don't tell jurors to tell us how you're going to vote. Isn't that exactly what we're doing here?
No. asking them as to Mr. Rafferty, I mean, with all due respect, I think the state's just completely ignoring the science, and I think the court is risking ignoring the science too, which is if you ask them simply, can you be fair and impartial in this? I know we're going back and forth, but I think it's related. They're always going to say yes. When you start asking them opinion questions that really, through a lot of thought of people who know about sociology and things of that nature, started asking, as Mr. Rafferty said, these attitudinal questions, then we're really going to be able to actually decide whether these folks are going to be able to be fair and impartial. To ask them simply, are you going to be fair and impartial? It is completely against all of the social science that is out there that says.
Yes, he is a bit condescending. Science isn't the law. Very true. And in fact, we are across a purpose. We do not get along. Science and the law do not get along. One of the hardest moments in the history of law was when CSI was a hit show, because then lawyers had to start trying to explain science to jurors, and that just wasn't good. I mean, in the end, it was very good, but to start with, it was a difficult road. But yeah, he is being a bit condescending. And this idea of saying, well, we can't just ask them if they're not going to be fair and impartial. Like, ask every other trial attorney and DA in the entire United States. Like, dude, what are you saying? Is this about semantics? You want us to change the words? Those 5 words are bothering you? Like, what's going on here?
Only people who are going to say no to that question are the people who want off this jury. Everyone else, if they're going to convince themselves, of course I could be fair and impartial. So when we start asking, do you think that Trump and his associates...
Gary, I love that.
And we start getting their opinion on that. Now we, as the court, of course, most importantly, but also counsel could chime in. Now we're really starting to see whether they truly can be fair and impartial. Because if they say yes to that, then, Your Honor, I'll just preview for you, we're going to have to strike them for cause, because clearly then, if they already say yes to that, they've prejudged this case. And because that's what the state is attempting to prove, that's the allegations in their indictment.
That's another thing about Mr. Lemonade that you'll see time and time again, is he's constantly doing digs against the state. And I think it's probably because he is a criminal defense trial attorney there in Georgia. So he probably comes up against the state all the time. And I have no doubt that there's like hard feelings between this side and then Mr. Lemonade. So he gets these digs in on the state constantly. But what you'll notice is Judge McAfee's like, you need to calm down, sir. You trust the system. If that's the case, why have the trial? Yeah, I mean, do you mean me? I trust the system? I don't necessarily trust the system. I just know the system. You can believe you're a victim of a case with already casting judgment. Right. I can feel the judge's irritation all the way in Oregon. Oh my gosh, yes. Trying to say a new jury can be impartial. Right. Do you think some attorneys are trying to get the judge to have a negative response on TV? No, I don't think so. Again, I think they're just too self-centered. Gotta go. Good to see you, Greg. I think they're just too focused on themselves. I don't think that's necessarily what they're trying to do. Although, I don't know about this guy. This guy right now is a wild card for me.
They've already come to a conclusion. They can't be on this jury. So these are simply the opinion questions that we think are getting to the true question the court is concerned with, which is, can you be fair and impartial?
The defense attorney.
We just feel like if you simply just ask them that and delete all this other stuff.
I got you now, Vanetta. Okay, I got you. Okay, yeah, the defense attorney. Oh my gosh, these defense counsel, they're working hard. I get it. But, again, it's all about how you're presenting it.
You're not going to get the right answer. And with all due respect, Your Honor, I'm not trying to reopen it, but if we only have, I know you said it wasn't 4 minutes and 15 seconds, but probably less than 10 minutes each juror, to Mr. Aurora's point, we're not just saying this. These we thought were questions that would help us go through that quicker, since Your Honor made such an emphasis, understandably, on we need to move through the jury selection.
Okay, a couple of questions coming by here. Excuse my ignorance, but are all defense attorneys working together? Oh, no. These, Cheeseboro has 2 attorneys here And I thought this guy was his assistant, but that's silly. He's clearly Mr. Not Lemonade's assistant. So no, I wouldn't say they necessarily are really working together. And then of course, Powell's attorneys over here, they all have very different styles. I think there's just, their egos are too huge to work together. They just wouldn't fit in a room together. So although they're kind of like, high-fiving each other to go tagging back and forth, but I don't think they're necessarily really working together on the case. For sure. Are they trying to set precedent for future defendants? Could be. It could be. But I doubt it again. I doubt it because I think they really are just focused on what they want to make sure the court has heard, what they want to get across to the judge. So I think that's really, really the key here, saying that no jury can be impartial with these questions. It seems like it's an interesting argument here because it's the argument we have for every jury, for every time we go in and do a jury. We always say, so what if you say, can you be fair and impartial? Those words themselves aren't going to really get you the answers, but that's like your job as the attorney, is that question gets you in the door, and then whatever response you usually get to that, even if it's a nonverbal response, that's what triggers the rest of your questioning. So he's saying those words themselves, the science is showing, that's not going to be helpful. And it's like, well, what words then do you want to do? And why are you the one that gets to decide which words I'm allowed to use? When it comes to something as basic as the question, can you be fair and impartial, which is the standard for voir dire.
Once they get here, this way we could focus on what's
I agree.
important when we get
Getting
up
too
there.
detailed. Yep.
Well, no, I mean, I certainly recognize and I'm sympathetic to the idea that part of the role a jury questionnaire does is focus what we want to do during the individual questioning, allow us to hone in on what matters. But at the same time, and then counsel's obviously permitted follow-up during individual questioning, but that doesn't throw out the general standards about what you're allowed to ask jurors, period. I mean, even if you put it on the questionnaire, if it wasn't on the questionnaire and you were to ask this question, you'd get an objection, and I don't see how I could not sustain that, right? I mean, I understand. I get completely what you're talking about when you say this is how we figure out what these jurors actually think. But ultimately, what I'm applying is decades of case law on this point that says we're not supposed to be asking jurors to give their opinion up front. You're going to be able to poke and prod all throughout individual questioning, and I think you're probably going to be able to find out pretty easily who is maybe a good juror for your theory of the case. But
if I could just say one thing, I just think, Your Honor, I would ask the court to just consider, even though the law is the law, and obviously if there is a case on point, then clearly Your Honor is going to apply it, and there's nothing we can say to convince you otherwise, because you should. I believe it would be a big mistake for any of us to treat this case like a normal case, because it's unprecedented in the history of Georgia jurisprudence. And in fact, I've heard people on both sides, MSNBC on one side, Fox News on the other side, they all agree on one thing. It's unprecedented in the history of American jurisprudence. And so I think the realities are going to have to start kind of really sinking in here to make us realize this is not an ordinary case. The reason it's not an ordinary case is not because of anything that we did. It's because of how they charged it.
Oh.
They could have charged it a lot different.
Rude.
And we have to do this case different. And of course, that doesn't mean going against any Court of Appeals or Georgia Supreme Court precedent. But to the extent there's not, pretty much, Your Honor, I think all of the case law says, I believe, in essence, when it comes to these matters, the trial court has a lot of discretion. And I just think this case needs to be treated the way it should be, which is a case that has no parallels in the history of Georgia or American jurisprudence.
Why stop there? Why not say the world?
Last word from the state on that.
I think you just heard it straight from Mr. Grubman. When he started, he says he wants you to disregard the law and the case law on what's going on just because it's a high-profile case. We still have to follow the law here, and we still have to follow. And what they're doing is basically asking them to prejudge the case and give them their ideas about their theories of defenses that they're going to prove. So we ask you not to ask these questions on the juror questionnaire.
All right, I'll take it under advisement. Next section in public officials.
I
where it
agree,
asked if you had
Kelly.
the following experiences. I think the defense had added in state convention.
Sometimes the best argument is the most simple. You don't have to put on a full 7-course meal if all you need for your answer is just, one plate. And I think a lot of times attorneys, because we're so trained to be the center of attention and we're trained to have all these arguments, that we'll go on and on and on and on. And at some point you realize that the most powerful statements are those where it's a precision moment, a precision argument, and it doesn't need to take 20 minutes. It just needs to be put forward and then you back away. Sometimes that can be absolutely the best arguments.
Event or national convention event, just as a line edit.
What does it mean to take it under advisement? It means he'll think about it. He does that. Yeah, he'll think about it. He's like, all right, whatever, I'll think about it. We'll see what happens.
That's right. Works 97 on the working copy. Any thoughts from the state on that line edit?
No, we're good.
Okay. All right, and also, you know what, I'll just do this for the record as well. I'm going to enter in the defense's track changes working copy as courts 3, and then the final questionnaire will be courts 4.
I think that's smart. There are a lot of
I think that takes us through the
write-ups
end.
on the defense's copy.
Just what did we agree? Where did the court land on number 88?
Where did we? Oh, 88 was the officer credibility. I think that if we're not including the one against the
I'm saying no.
defendants, the case law supports that being excluded as well. So I would strike 88.
Is he left-handed? Oh, he is. I didn't even notice that. That's a good
Anything else from the state, just
observation.
on the questionnaire in general? Is there anything we need to tailor on that's to precede the witness list? Right now it says circle the name of any individual, do you have any association and or direct or indirect connection with?
Whatever it takes for you to leave me alone.
While we're talking about witnesses, we did have some follow-up that we'd like to
Accurate.
take the court outside of the.
Okay,
That's okay.
we will do that. Anything else from the state? Or excuse me, defense?
Thank you.
Okay, Mr. Aurora?
Judge, the record, I wanted to maintain the objections. I know we've sort of
Sure, of course.
back and forth, but
No. Any objections to what does not make the final cut are lodged for the record and noted. Okay.
can I address something different?
Sure. I think I'm just last call for anything on the questionnaire. Then I'll try to get you that final copy by. I'm going to try to do that today. I'll send that by email. Okay. We can open it back up to anything else.
The grand juror issue, Your Honor, you're making your emails and their responses exhibit record.
That's right.
And so,
So all the declinations I was going to file under seal.
okay. That's fine. And then what courtroom did you decide that Roger going to
Still working on that. We are trying to get one of the larger ones on the first floor. We're still going to be doing individual voir dire in here. But so for those 2 weeks that we're doing individual voir dire, give or take, we will be in here. And then we're going to line up a larger courtroom. For the trial itself?
No, just for during jury selection when the defendants are here.
That's a great point. So during jury selection, is it going to be the same 3 and 5?
Or, I mean, there'll obviously be 2 more.
We can fit 4 chairs at that longer table that y'all are at.
And we can put a couple of the associates in the first row.
I think we might.
Next to the defendants, so we'd have some.
Yeah, I think we might need to do that.
Maybe reserve. I think your court has already offered to reserve the first row.
Right.
For teams.
Okay. So with that, there would still be enough room for the clients and lead counsel.
I agree, Corey.
Be passing notes and questions and whatever else you need to do.
As long as you're okay with the first row coming
Yeah.
up here to hand me stuff. Without
Yeah, we'll remember to block that out. Of course, I can imagine there'd be a throng of folks clamoring to see individual Voir here for 2 weeks, but we'll see.
Wait, hold on. Did we get a ruling out of DC? Is that what everyone's talking about? Do we have a ruling? Oh my gosh, I'm waiting. It's in court right now. What's in court? What's in court? Okay, not yet. Not yet. Okay. Partial. All right. I'm on pins and needles here waiting for that. Oh, hot dog. Oh my gosh. Okay, it's partial. All right. Limited gag order approved. All right. Well, I guess we'll know what I'll be going over tonight on the live. So I know, right, Lisa?
See.
I mean, they're here to see even.
I know. It's riveting stuff.
Washington Post, New York Times, everything.
Okay. What else? Yes, sir.
Just what we.
When we're done for now, though, on the record, anything else? Okay. All right, we'll be off the record. We'll see you Friday.
Okay.
Smith.
Court's adjourned.
For you.
So this is the true hero right here. This court reporter, that's the true hero. Lest we forget. Lest we forget. So, yes, we'll do a quick wrap up here. Yes, we'll do a quick wrap up. So what we've got going on here is the initial jury questionnaire. So we've got the venere, which is the huge group of people called in for jury duty. They fill out the questionnaire. A whole bunch of them are immediately eliminated. After that, we go through another process of questioning and then start going through the process of voir dire. So this is just that very first setup. We're going to have our first panel, or our first venere, our first group, 450 jurors pulled in on Friday. They'll have to fill out this questionnaire that will be eventually approved. And from there, again, probably half will be eliminated just for basic reasons. And then after that, they start to kind of make it smaller and smaller. It's a process of elimination. Picking a jury is not a proactive, it's a process of elimination. So you cross out people that you know are not going to be good. That's how you get to the jury that you want. But that's what is going on here. And then we've got, so we have the state's attorneys here. We've got defense counsel over here, and then the judge going through and talking about the questions. We have to be careful with the style of questions. We don't want to prejudice a juror or the venere before it even begins. So we've got to be careful about that. That's why the judge wanted to go through it. He said we will not have another hearing on the jury questionnaire, so it will probably be sent out. They may have, again, objections, but almost all of these objections and all of these things are being made in case for appeal. That's really what this case is going to be about. So all of those things will be noted and put into the record, but that's about it. So that's really what this hearing was about. Thank you. You're welcome, Jilly Bean. Prohibits all parties from all statements publicly targeting special counsel, his staff. Ooh, okay. We love that. We love that. Yes. So the other huge hearing that we have going on today, of course, is, let me show you here, is that we have our gag order hearing at 10 a.m. in DC. So that's what we're kind of talking about a little bit here in the chat to figure out what's going to happen with Judge Chutkin. So that hearing's been going on. We're kind of waiting on an order. I will be back again live tonight, everybody, 7 o'clock Central Time. I plan to go through any updates out of the DC case, so that DC hearing that we had today, brief recap of the Trump cases, but then I would also like to take everybody through the Colorado lawsuit on the 14th Amendment Section 3 challenge, where they are challenging Trump's ability to actually be on the ballot. That motion to dismiss was filed and rejected, so it was dismissed by the court last week, so it is proceeding to court. So I will take everybody through that petition tonight. I did do it once before on YouTube, but I have not done it on TikTok, so I thought that would be worth it. I did need to kind of redact some of the words just so we don't get into any trouble, but that should be very interesting tonight to kind of go through those issues now that we know it's going to be put on the docket. So that's the plan for tonight, everybody. I will be on 7 o'clock Central Time. Thank you all again for coming and hanging out. There will be a lot more of these watch parties as we get closer to the trial. So I will say goodbye to everyone now. Take care. Have a wonderful rest of your day, everybody. Yes, yes, take care. Have a great day. Thanks for stopping by. And as always, thank you, moderators. You are amazing. Thank you so much.